right, this is case number 23-4-8456. This is Alden Towers versus Ryan Rollins and other occupants of property located at 8104 East Jefferson, C707. The court also at this time calls 23-4-8464. That is Alden Towers versus Darrell Gavin and other occupants of property at 8100 East Jefferson, number A207, bracket 201. The court calls the suffix 8003, that's Curtis Murphy versus Rashawn Green and Monique Tryman and other occupants of property at 7744 St. Mary's. Your appearance at this time, counsel.
Good morning, Your Honor. Mark Corey P. 82210 on behalf of plaintiff for these matters. A couple of these are going to be dismissals, Your Honor.
You may at this time.
The first one for Rollins and Alden v. Rollins, that one will be a dismissal.
All right, that's the subject 456. That matter will be dismissed. Go right ahead, sir.
The next one, Alden v. Gavin and A201, that one is continuing at this time, Your Honor.
Which one? I'm sorry.
Alden v. Gavin is continuing at this time.
So the suffix 8003 will be dismissed. You said two are being dismissed?
There's a couple here. Sorry, Your Honor. Let me just go through the dismissals first. That's probably the easiest way. The first dismissal, case number 8456, Alden v. Rollins is a dismissal.
Thank you.
The next dismissal is that is green. The next dismissal is case number, I can't even read that. It's the Curtis Murphy one. My copy, I can't read the case number on, Your Honor.
Oh, geez.
That's the suffix 8003. That one's going to be dismissed as well, counsel?
Correct, Your Honor.
All right, I will then order to dismiss with respect to both of these matters at this time. The remaining matter that is before the court at this time is the suffix 464 that relates to Alden Towers versus Darrell Gavin. Do I have someone representing Mr. Gavin or Mr. Gavin on this one? Mr. Gavin, if you're here, say something, please. All right, it appears that this is the first hearing on this matter. Mr. Gavin has not appeared. Pursuant to the administrative order, I will grant a first adjournment regarding this matter. We'll set the new date for the 5th of February. 25/21. That'll be set at 10 o'clock a.m.
Thank you, Your Honor. I do have two more cases. One more is a dismissal that's scheduled at 10. I'm happy to provide that dismissal now, or when you call me for my next matter, I'm happy to provide it then.
Let's see if we can get to let's see if we can address your dismissal. 1 second, sir.
Thank you, Your Honor.
What's the suffix on your dismissal in the 10 o'clock hour, sir?
It is ending in 8488, Alden Towers v. Adam Angelus.
All right, I do have that matter, and that matter 23-4-8488, Alden Towers versus Adam Angelus and other occupants of property at 8104 East Jefferson, number C403. On counsel's request, that matter will be dismissed at this time.
Thank you very much, Your Honor.
Thank you, sir. All of these are dismissals. The court now calls 23-4-8460. This is Conde versus Louise Anthony McClinton and Alexis LaShawn Harris and other occupants of property at 11558 Wayburn in the city of Detroit. The court also calls 19-361-591, that's Derek Hardaway versus Arthur Herndon and other occupants of property at 7873 Helen Street.
What's the case number, Judge? You didn't give the case number, I'm sorry.
That's 19-361-591. All right, your appearance on these matters, Counsel. Mr.
Randy, you're up and you're muted.
Sorry, my apologies. I was just wrapping up another courtroom. Good morning, Your Honor. Randy Levasseur, P41712, appearing on behalf of plaintiff.
Thank you, Counsel. With regard to the suffix 1591, that matters before the court on a pending application for writ of restitution. Do I have Arthur Herndon on the Zoom or anyone at the address of 7873 Helen Street? Say something if you're on the Zoom. All right, Counsel, your pleasure regarding that matter, sir.
Good morning, Your Honor. Randy Levasseur, P41712, appearing on behalf of plaintiff. This is a writ hearing, and my notes indicate that it's the first actual writ hearing with the court previously scheduling for a time when which could not take place because the court was closed, Your Honor. Our request would be for issuance of the writ if the court believes that it can issue it, otherwise setting it forth for a second hearing.
All right, the court will set the matter on for a subsequent hearing in this matter. I will set that for the 28th of January, 1/28/21, and that'll be set at 9:30 a.m.
What date, Judge? I can't hear.
January 28th, 2021, 9:30 a.m.
Thank you.
And the other one, Mr. Dyer, it looks like that's a first hearing. Do I have McClinton or Harris on this Zoom? Anybody living at the Wayburn address? Say something if you're on the Zoom. This does look like a first hearing. All right, say something. What's your name?
Richard McLean.
All right, thank you, Mr.
Richard McLean. Richard McLean.
Mr. McLean, do you live at the property on Wayburn Street?
No. This is for
well, that's
I
not
live
you
on
then.
Secluded Lane, and
Let me stop. The only person I
No,
want to talk to is someone that lives at the property at 11558 Wayburn. You live at that location, speak now. Thank you. All right, sir, I'm going to reset this matter for the 5th of February the 5th, 2021. This matter is going to be set on 9:45 on that date.
Thank you, Your Honor. I have another matter, but it's not up until 10:15 this morning.
All right, we'll address it as quickly as we can get to that one, sir. The
Thank
court
you.
is now called 23-4-6-906. This is Denard White versus Arthur and Najee Powell and other occupants of property located in the city of Detroit at 16157 Washburn. It appears the parties have reached an agreement and have offered a proposed consent order of conditional dismissal. Your appearance for plaintiff.
And Judge Joe Horta, P75969 for the plaintiff.
Thank you, Mr.
Judge,
Thank you, sir.
please the court, Steve Lockhart, standing in for defense attorney of record, Valerie Dahlstrom.
Thank you, counsel. And counsels, respectively, it appears that there is an agreement that you wish the court to sign at this time that resolves this matter on a conditional basis. Is that correct, Mr. Horton?
It is, Your Honor.
Mr. Lockhart?
Yes, Judge.
All right, do I have the Powells or either of the Powells on this Zoom at this time? All right. I do see there's been a sign off on the agreement. I will sign the order at this time.
Thank you, Your Honor.
This is case number 23-42460. This is Coleman Incorporated versus Elizabeth Porter and other occupants of property at 13674 Wadsworth in the city of Detroit. The matter is before the court after entry of, I don't see the judgment, but apparently a judgment. Yeah, I see it now. There was a judgment in it on the 27th of February, 2020. That matter was adjourned in the pandemic, and now there's a pending application for writ of restitution. Your appearance at this time, plaintiff. Do I have Mr. Fantera present on this Zoom? All right. Do I have Elizabeth Porter, or anyone living at the Wadsworth address on this Zoom? Please say something at this time. All right, that matter is set on for 9 o'clock a.m. I will try giving it another call a little bit later in the call. The court calls case number 23-45685. This is Skyway Properties Incorporated versus David DeMeach and other occupants of property located at 13535 East McNichols, Unit B6. Your appearance at this time, counsel.
Good morning, Your Honor. Nasreen Hamoud, P number 80522, appearing on behalf of the plaintiff.
All right, thank you.
Judge.
Your appearance, please.
Judge Steve Lockhart, P32090 for defendant. Need to address when you wish.
All right, please update me, Mr. Lockhart, regarding this matter.
Judge, I first had contact with the defendant in August of last year, along with plaintiff's counsel. At our last hearing, we adjourned to process EDP. Ms. Hamoud has presented me with the documents necessary from her client. My client has not, despite my repeated phone and email requests. On December 10th, I sent him a letter indicating I was going to withdraw from his case. I have not heard from him since December 10th. However, last night at 4 o'clock, he left me a voicemail, and he has attempted to call me twice this morning while I've been occupied in court, and I have refused and neglected to try to answer his calls while I have other things to do. It appears he's trying to connect at last minute. I did send him connection instructions in my letter of December 10th. Our resources are limited, and I would respectfully ask to withdraw, although I can tell you he's apparently trying to get to me this morning as we speak.
All right, I do realize the limited nature of the resources there. Are you convinced that there is a breakdown in the attorney-client relationships to the extent that could not be repaired, you could not go forward in this matter? Counsel, do you want to solve this?
Reluctantly, yes, Judge, unless for some reason Ms. Hamoud wants to keep the case alive with my assistance, because under the new grant that's coming down on February 14th, if Mr. Dimich gets in his documents, Ms. Hamoud's client could see some economic compensation for the hit they've taken for the last year. But unless Ms. Hamoud wishes me to stay in this case to assist, I would like to be out with the court's permission.
It's certainly not a classic petition for withdrawal, Ms. Hamoud.
I do appreciate that, Mr. Lockhart. However, in light of Mr. Dymock's lack of cooperation throughout the case, Your Honor, we are requesting entry of a default judgment. I just don't anticipate his further cooperation. In fact, he has never appeared to any of the hearings, despite Mr. Lockhart being present.
All right, now let me see. Is Mr. David Dimich on this Zoom?
Yes, Court Judge.
Say something if you're on this Zoom, sir.
Yeah, he has.
Why is that? He's at the Zoom. over and over again. It's a simple proposition, and he's had counsel to work with as well, and hasn't responded. And I think that this is one of the most help-filled times that we've had in the history of this court operating. At this time, I'll grant your petition for entry of default judgment. I'll also grant a petition to withdraw. Counsel has been quite diligent in wanting to assist the defendant in this matter. The defendant has shown no tendency and no commitment to follow through on what is required. The counsel should not have to carry on in this matter without having the assistance of his client to help towards his objectives. Accordingly, I'm allowing plaintiff Mr. Lockhart to withdraw from this matter. Judgment will be entered by default, and I await the order of this.
Judge, do you need me to present an order of withdrawal?
That would be great, that I may document it in the file, so thank you.
I will do that. I will also send Mr. Dimich another letter telling him what's happened today.
Thank you, sir.
Thank you, Your Honor.
Your Honor. What was the last one? Okay.
Hello?
Yeah.
I'm sure.
Yes.
Judge, may I interrupt you?
I have it up there.
I wanted to see it.
Oh, you.
Ms. Hammoud, please stay on.
I'm listening to you at this time, Mr. Lockhart. You may.
I just got a voicemail from Dimich that says he's outside of the courthouse. For whatever Your Honor wishes to do with that information.
My order stands.
Yes, Judge.
You want to know, let's see, dismiss, I want to know if it was a dismissal in there. Yeah, P in this one.
Thank
You want to know.
All right, this is case number 23-4-7251. This is Lumbar Assets Management versus Martinique Parks and other occupants of property 4635 Corville, the upper unit. The court also calls the suffix 6494. That is Detroit Rock versus Willie Barquette and other occupants of property at 15114 Littlefield. Your appearance at this time, Counsel.
Your Honor, for the record, Attorney Frederick Coleman, P 56548, on behalf of the plaintiffs. What was the first case number? What was the first case number, Your Honor?
The first one was
7251.
7251, and it looks like there is an agreement for a conditional order of a consent order of dismissal in this matter. Mr. Coleman, is that correct, sir?
Is pardon me, that's the one ending in 251?
Yes.
That's
Yes,
correct, Your Honor.
Yes, sir. And someone, Mr. Santiago, is present on this Zoom?
Judge Steve Lockhart, I will stand in for Robert Santiago for defendant.
Thank you, counsel. And it appears that there is an order for EDP funds together with other conditions that are set forth before the court. And you wish that I sign off on that, Mr. Coleman. Is that correct, sir?
No objections, Your Honor.
Likewise,
And
Mr.
Judge, can I verify again? That's Lombard versus Porter.
That is correct.
Judge, I will.
Parks is the last name I have. Martinique Parks.
Understanding, I will let Mr. Santiago know that the conditional dismissal entered today.
Thank you, counsel. And Mr. Coleman, you have the suffix 6494. I believe there was some indication that this matter should be dismissed, sir. Go ahead.
Your Honor, for the record, Attorney Frederick Coleman, P 56548. There was an agreement with Attorney Valerie Dahlstrom. I thought she had entered it already.
May I, Judge?
That may very well be the case. Mr. Lockhart?
Judge, I received an email from Ms. Dahlstrom this morning indicating that a conditional dismissal was sent to Mr. Coleman, that the defendant has approved the conditional dismissal and grants Ms. Dahlstrom authority to sign, but it appears Ms. Dahlstrom felt that Mr. Coleman still needed his approval and his client's approval. If Mr. Coleman is good with the conditional dismissal and you have it, let's enter it.
Your Honor, I believe my officer contacted Mrs. Dahlstrom. It might have been a lack of communication. I did authorize her signing electronically on my behalf in settlement of this matter.
All right. So I'm going to mark the file as dismissed, conditionally awaiting order, because I don't have it yet. Is that
Mr. Coleman, do you happen to have the order?
Hold on. Can you hear me?
Well, I won't stay here. I won't stay here unless you guys put that out. It seems that there's not a dispute as to whether or not it's dismissed. So I'll just await the order.
Well,
Thank you, Your Honor. I have another matter at 11 o'clock for Mr. Ravis. I'll be back shortly. I'll call you shortly.
Thank you. And I do see Ms. Coney on this Zoom, and Ms. Coney was in relationship to this particular file that we've been talking about. Ms. Coney, you understand that there's going to be an order entered that is initially dismissing this case based upon some eviction diversion funds. Is that correct, ma'am?
yes, from what Ms. Valerie explained to me, and she emailed me also saying it'll be a conditional of me being out by March 1st.
Oh, okay. So you worked something out for a March 1st.
Yeah,
Okay.
she said she had talked with Mr. Coleman and everything last night.
And that is correct, Your Honor.
All right, ma'am. So I'm going to sign that order once it's presented to me, and you can govern yourself accordingly, because that's what the outcome of your case is, right?
Mr. Coleman, I'll take responsibility for getting that sent to the court, sir.
Thank you, Steve.
Good day to you, Ms. Coney.
Thank you. You too.
All right, the court calls case number 234674. This is NBA Management Company versus Sherry Park and occupants of property at 12808 Riot. Counsel, your appearance this time, sir.
Morning, Your Honor. Ely Bajani on behalf of the plaintiff, P74626.
All right, thank you, Mr. Bajani. Is there anyone on the other side of this? Do I have Sherry Parks? Ms. Parks, if you're on this Zoom, say something at this time. All right. So it looks like, counsel, that there was a previous hearing on this matter. It was adjourned, and then the shutdown. So your pleasure at this time, sir.
Your Honor, I'm sorry, I was muted. Angela Malvik, P83921 with Lakeshore Legal Aid on behalf of Ms. Parks.
All right, thank you, Madam Counsel. All right, update me on things here, please.
Sure. So today was a control date set last week for me to get in contact with my client. We did go through the EDP process. Mr. Bajani and I have negotiated a conditional dismissal. However, I've been unable to get in contact with my client for several weeks now and don't have her authority to proceed on the conditional dismissal. So unless Mr. Bajani's client is interested in keeping the case open for EDP 2.0, I would request to withdraw from the case at this time.
Your Honor, in response to that, I would suggest that we enter a default judgment, and in the event that the defendant does appear, we can set aside that judgment and move forward with the EDP. But Your Honor, this is our 5th hearing, and the defendant had plenty of opportunities to communicate with counsel, and she has failed to do so. So therefore, we're asking for entry of a default judgment.
All right, I will grant counsel's motion to withdraw Ms. Mulvey Under the circumstances, I believe that she's worked diligently to get this matter to resolution, and the client has not been in cooperation or reasonable contact. In regard to this matter, then, I will grant the petition for default judgment, and I will sign the order upon consent.
Thank you, Judge. And I have emailed your clerk proposed default judgment, so it should be in the file.
Okay. Today I have with me
Ms. Banks.
Ms. Banks. So if you could email it to
Carmen.Banks. Tell them it's the same format.
I have.
of course, Carmen.Banks@36districtcourt.org. Carmen.Banks.
Got that. I already emailed Ms. Banks.
Okay, thank you, sir.
Judge, this is Lockhart. If I could interject, is Carmen CARMAN or EN?
Ian.
Thank you. I got some to send you, Carmen.
Thank you very much, Judge.
All right, this is case number 20-348016. This is Lennox Property Management versus Karaja Huff regarding property at 14157 Burwood in the city of Detroit. The matter is before the court on the filing of a complaint for non-payment of rent. The matter was adjourned until today's date to give opportunity for re-notice of this matter. Your appearance at this time, please.
Query side, P67390 on behalf of plaintiff, Your Honor.
All right, thank you, Ms. Simon. Good morning to you. Do I have Huff on this Zoom? Someone living at the Burwood address, 14157. You're on this Zoom. Please say something at this time. That is Huff at Burwood. All right, this is the second hearing in this matter. I suppose, counsel, that you're requesting the court enter judgment by default. Is that correct?
That's correct, Your Honor.
I will grant your petition for entry of judgment by default. I'll sign the judgment upon presentment, and so you'll email that in so I can sign off on it.
I will,
Thank you.
Judge. I'll do that this morning.
Thank you.
Thank you. Have a nice day, Judge.
Likewise to you. All right, this is case number 1934, strike at 19359-684. This is AT Homes RE LLC versus Samuel Hamilton and other occupants of property at 14888 Mendota. Your appearance at this time, counsel. Next problem, do I have you here? Do I have Ms. Willingham?
Judge Lockhart for Willingham. Miss Willingham emailed me this morning. She's indisposed.
Yes.
And I have no knowledge of the status of this case.
Well, I know I set it for a review hearing today. I don't see Ms. Prop on the Zoom either. And it was set for 9:00 a.m. So I'll come back to it again, and we may have to just reset the date on that matter. All right, this is case number 20-340612. This is Lewis Apartments versus David Jeter and other occupants of property at 20520 Plymouth Road, apartment B6. The court also calls 20-340615. Thank you, sir. This is Parkview Tower and Square versus Leah Owens and the occupants of property at 1601 Robert Bragg Drive, number 1008. Court calls the suffix 34, strike at 3559. That's Lewis Culfer LLC versus Devontae Evans and Tanisha Lacey and other occupants of property at 20544 Joanne Street. The court calls the suffix 7174. That's Maju, MAJUA LLC versus Joel Asbury and Sandra Asbury and other occupants of property at 1510 Leisure Street. The court calls, strike that, Counselor, your appearance at this time on these matters.
Good morning, Joe Horka, P75969 for the plaintiffs, Your Honor.
All right, thank you, Mr. Walker. Are there any attorneys representing any other persons that I called in these files? If you are, please, in your appearance at this time, that I might address your matter.
Anita Owen?
You're not an attorney, are you?
No, I'm in the case.
Hold tight for a moment, ma'am, and listen carefully.
Thank you.
All right, do I have
Thank you.
any attorneys at this time that are representing any of these persons? Speak up now.
Judge, this is Lockhart on file ending 174 Asbury.
Thank you, sir. And Mr. Lockhart, if you will update me on 174 at this time, sir.
Judge, this matter was adjourned till today, I think from the 7th of January, I'm not positive. We have an EDP calculation saved under the first program. I have not talked to Asbury in the last 2 days. Is Mr. or Ms. Asbury connected?
Either of you are on the Zoom. Asbury, please say something now. Anybody at the leisure address, speak up now if you're on the Zoom.
Judge, Mr. Horka and I talked about this case this morning. I'd ask for a short adjournment to protect Mr. Horka's client so I can iron something out with my client.
That makes sense.
Mr. Horka, did I state that correctly?
Your Honor, Mr. Lockhart and I discussed a mid-February return to evaluate EDP at that time.
Mid-February would be great, assuming we can go forward, Joe, but I don't have an answer on the other issue we discussed.
Understood, Steve.
Rather than anticipate 2 additional adjournments, there's some life in it. I'd rather go ahead and set it forward now. I'll set it over for the 9th of February, 9 o'clock a.m. 2/9.
Judge, if I could interject, the problem with that adjourned date is we will not have full information about the new program until mid-February.
Well, and I've heard that, and I've adjourned a number of cases until the 5th. The hope here is that there will be enough information to begin the process. And I would rather be on that and maybe be finished by the time the matters come out. So I'm setting it for the 9th at 9 o'clock a.m. this time. Thank you, Mr. Locker.
Thank you, Judge.
Any other attorneys on any of the other matters that I've called, these other 3 matters? All right. Let me ask now then, is there anybody on this Zoom regarding property on Plymouth Street, apartment B6? If you're on the Zoom, say something at this time. This is a application. Say something if you live at the Plymouth address. All right. This is the application for writ of restitution in this matter. Sir, the court previously signed a writ on 2/2020. After that, the pandemic set in, and I believe there was a hearing in the interim. In any event, there is a remaining petition for a writ application, sir.
Your Honor, my client has given me permission to request that the writ be withdrawn.
All right, so the writ will be, the court will allow me to withdraw the writ at this time. And so this case should close out. Is that correct, counsel?
Yes, please, Your Honor.
Judge, what case number is that?
That is the suffix 612. 612. All right. Regarding the suffix 615, do I have Anita Owens or any occupant on Robert Bradley Drive, 1008 on this zone? If so, say something now.
Anita Owen.
Connor Brown, attorney from Lakeshore Legal Aid here. I'm actually representing Ms. Owen. I apologize. I didn't hear you call that case number earlier.
All right, thank you, Mr. Brown. Mr. Brown, you want to go ahead and update me on this matter, sir? Any information you can bring to me?
Judge, before Mr. Brown does that, I can indicate to the court that we're requesting that this writ be withdrawn at this time.
All right, so Ms. Owens and also Mr. Brown, the writ application, there's a motion to withdraw that application. I suppose that there's no objection to that the same, is that correct, sir?
That's correct, Judge.
All right, thank you, Mr. Connor. Your P number, sir?
P79949.
All right, you understand what's going on here, Ms. Owens? Ms. Owens?
Hello? Yes.
Yes. All right, so that will close this file because the writ is withdrawn.
Oh, I couldn't hear. There's a buzz.
Hello?
There's a buzz in the phone. I couldn't hear what you said.
All right, yeah, that was somewhere else. I think I took care of that for now. So the writ is withdrawn in this case, and that will close this case out.
Thank you.
Thank you, Judge.
All right, thank you. Good day to you. Thank you, Mr. Brown. I'm sorry.
Thank you so much.
All right, all the best to you. And finally, Mr. Harker, regarding the suffix 3559, Devontae Evans, Tanisha Lacey, any occupants of property on Joanne Street, 20544 Joanne Street. If you're on this Zoom, please say something at this time. It appears that judgment was entered in this matter by default on the 19th of February 2020, and there's been a pending application for writ since September of 2020. Counsel.
At this time, plaintiff is requesting to move forward on this writ and requesting the court sign the order of eviction.
All right, the court will sign the order at this time, allow the writ to go forward. The court will allow for execution on the writ on or after the 5th of February. The writ may be executed on or after that date.
Thank you, Your Honor.
Thank you, counsel. This is case number 23-48479. This is Rotten Holdings LLC versus Zalitra Brown and other occupants at 7829 Woodmont Street. Your appearance at this time, counsel.
Yes, Your Honor. May it please the court. My name's Dennis Flesland, P30289, appearing on behalf of the plaintiff. I am standing in for Mr. Sagatti this morning, Your Honor.
Thank you, sir. And do I have on this Zoom, do I have Ms. Brown living at Woodmont Street? If you're on this Zoom, please say something at this time. Steve Brown living on Woodmont Street in the city of Detroit. If you're on the Zoom, say something at this time. All right.
Your Honor, our file reflects personal service in this matter.
All right. I don't have that in front of me, but I will, however, set it over for a next action date. That is the first hearing after the pandemic. So I'm going to go ahead and reset it. I'll set it over. We'll get notice for the next hearing. I'll set it over for the 28th of January. 1/28 of January. That'll be at 9:00 a.m. We'll renotice the matter. Give the defendant opportunity to come in.
Very good. Thank you, Your Honor.
Thank you, counsel. I have Mr. Waldberry.
Hi, Judge.
All right, this is, good morning to you, sir. This is case number 23-46992. This is Rose Community Management versus Isaiah Woods and other occupants of property at 15400 West 7 Mile Road, apartment 312 in the city of Detroit. Your appearance at this time for the plaintiff.
May it please the court, Mark Wasbury, P 51575 on behalf of plaintiff.
Or defendant in this matter, please.
Cody Brooks, P 83108 with Lakeshore Legal Aid for Mr. Woods.
All right, thank you. And Mr. Brooks, if you will update me regarding the status of this matter, sir.
Certainly, Your Honor. I don't see Mr. Woods in the participants list unless he's one of the phone numbers. Mr. Woods, are you here?
Say something if you're there, Mr. Woods. Living on West 7 Mile Road, number 312, Mr. Isaiah Woods. You may continue.
Your Honor, I've spoken with my client. He denies the allegations in the notice to quit. And we discussed a motion, which I would bring at this time if the court would permit me without Mr. Woods being here. Otherwise, I made sure Mr. Woods had the link to connect this morning and knew that the time was at 10 a.m., but it does not appear that he's appeared.
All right, and what is the nature of your motion, counsel?
Your Honor, the notice to quit is dated on June 1st. Thus, it was served during the moratorium. The 36th District Court's FAQ is quite clear that no notices to quit were to be served during the moratorium based on Executive Orders 118 and 134. So based on the bad notice, I would ask for this to be dismissed. Mr. Wasbury has filed a second notice to quit for a subsequent case against Mr. Woods. So he would not be without remedy if this case were dismissed.
Your Honor, I'll respond. First of all, this is the third time we're here. The second time that Mr. Woods has failed to appear. I have 3 witnesses on the line. I would ask for a default. We were certainly allowed to send termination notices. Perhaps there was something regarding non-payment, and I was not doing, there was just nothing.
Excuse me, I'm sorry, Mr. Walker. Ladies and gentlemen, you will have to mute your device until the court comes to your case. Otherwise, it creates too much sound in the system. Thank you. It's part of the interruption, sir.
Thank you, Judge. So the position that we were not allowed to send termination notices simply is not true. There were certain non-payment restrictions. And again, Mr. Woods is not here. I would ask for a default. This is highly unfair to my client. There was a stabbing in this apartment in December. There's unauthorized occupants living there. When they lose the key, they kick in the door. I'm respectfully requesting a default judgment against Mr. Woods and all occupants.
May I respond?
In just a moment. I can't, Mr. Weiser, I can't address the very difficult issues of those factual allegations that you have presented because of the status of the case at this time. I guess that the issue here is whether or not you could proceed on the complaint that was filed. It is a termination action, Mr. Brooks.
I'm sorry, you cut off there, Your Honor. It is a termination action.
Proceed at this time. I was addressing Mr. Wasbury and saying that those factual allegations do not seem to weigh in at this point because this either sounds like something where there is a motion to dismiss that has or does not have validity, and if that doesn't have validity, it would seem under these circumstances that plaintiff would be entitled to entry of judgment by default at this point. Counsel.
Simply that the executive orders contained a preamble that it is to prohibit the removal or exclusion of a tenant from or mobile home owner from their residential premises except in extreme circumstances. It is no person shall remove or exclude from leased residential premises. The order is broad. Yes, there is a specific paragraph that applies in the non-payment context. However, from the 36 district courts frequently asked questions published on July 24th, question number 5, are plaintiff landlords prohibited from serving a notice to quit or demand for possession on their tenants during the moratorium? Answer 5, yes, they are prohibited from serving such documents during the moratorium. See Executive Orders 2020-118 and 2020-134. Based on this, the court's interpretation appears to be that notice to quit was also improper during the moratorium.
Yeah, and Mr. Wasbury, that does appear to be the significant driver here. The way at least this court interpreted that was that there was a prohibition from serving notices during the relevant time that is the subject here. And obviously the court has grave concerns where there is significant delays in this issue coming up, because obviously notice was given in June, the matter is brought before the court in July. Then we have a hearing sometime in October, and the court gets, the matter gets shut down for months, and here we are at the starting place. I do believe that on that technical issue that counsel is correct. That is Mr. Brooks, that pursuant to the administrative order that the notice could not have been served during that time. Anything else, Mr. Wasbury?
Yes, Your Honor. The frequently asked questions he referred to was for July 24th. The summons issued in this, well, the notice was sent well before July 24th, almost 2 months before. It was sent on June 1st. And I don't think Mr. Woods has any standing to defend based on he's not here. And I would respectfully request a default judgment.
I am here. I've been sitting on mute. I've been here. I just was setting up the.
I asked for your appearance, your presence earlier, and you didn't respond. But that's okay. Your attorney is here. All right, Mr. Brooks. I mean, I understand that that the formulation of those written items came at some point later. But that was the court's interpretation of how the rules applied in this matter, and that's the issue that Mr. Brooks is raising. It is with a significant degree of hesitation, given some of the things that I've heard about in this case, that I will grant the petition to dismiss at this time, based upon the notice being filed in the period filed under the emergency order. That would be the court's determination. This case would.
Breaking up, Judge.
I'm sorry.
Since you're kind of breaking up.
All right. So the case is going to be dismissed for the reasons indicated on this record. That does not prejudice the right to rebring this matter, but this case is dismissed.
Your Honor.
Thank you, Your Honor.
May I place an objection?
Yes, sir.
I do believe there are extreme circumstances in this instance that would allow my client to proceed. I respect the court's ruling, but I wanted to place my objection on the record.
So noted, sir, and clearly the court has granted a dismissal. If you find something that you can formulate and submit electronically as well as to Mr. Brooks, I'll review it in this matter, because we want to be right going forward, especially when there's been such a significant lapse of time. But I do think, based upon everything that I've been able to observe, my understanding in this matter is that the notice could not have been filed during the time that it was filed in this particular case. Right. That is my order. I wish you well.
Thank you, Judge.
Thank you, Your Honor.
All right, this is case number 2348452. This is Malaysia Investments versus Tony Coates and other occupants of property at 20486 Fleming Street, number 204. Let me hold on that one. I see Mr. Ventura. I called this earlier. Case number 203-42460, Palawan versus Elizabeth Porter. I called that matter at earlier times. Application for writ of restitution The judgment was entered on the 27th of February 2020. Counsel, your appearance, sir.
Good morning, Your Honor. David Fantera on behalf of the plaintiff, and I apologize. I've been juggling 3 courts this morning, and I tried to get over between my other 2 hearings, and so I apologize.
Not a problem. Just wanted to kind of get back to it since I think this is the only one that you have. Is that correct?
Yeah, and let me briefly explain what happened in this case. I called your court court reporter earlier.
Not me. You mean the clerk? I'm sorry.
Okay, then I called the clerk. I apologize.
Madam Reporter, stay out of this. Take the record. Don't make it. Thank you. All right, now, Mr. Fantera, I apologize for the interruption.
You're fine. Okay. We took a consent judgment against Ms. Porter on February 27th that she had to pay $800 within 10 days. She paid that amount. And I think she paid it on March 13th. And then my client, I represent the management company. My client terminated its contract with the owner. And then in October, I believe in October, the new property manager filed a writ. And so you'll see that the writ that's in the file is not signed by me. It's not signed by another attorney. I believe it's signed by a property manager. And I only found out about this because I got a notice in the mail, and then Ms. Porter called me and said, "What's going on?" And I'm like, "I didn't file anything." And then I got a call from a property manager, I think her name is Miss Jones, and she said, "Would you represent me at this hearing?" And I said, "No. Number one, you shouldn't have been able to file anything because this is a corporate attorney, the corporate client." And she said, "Oh, I just moved here from Atlanta. We could file things there." And I said, "Well, you can't in Michigan." And I said, "Second of all, the judgment's paid off. Miss Porter may owe them additional money after February, but this judgment is paid off. So that writ should not be signed, and Miss Porter should not be evicted on this case."
You're very correct with that information, sir. I will allow for the withdrawal of the writ application. It will be withdrawn at this time, and the case will be closed. Obviously, they can bring another case if there's other rent that's owed. But that's the end of this case. Thank you, sir.
Thank you very much, and you have a great day, Your Honor.
Likewise, sir. Continuing, I did call the suffix 8452. That is Malaysia Investment versus Tony Colton, other occupants property at 20486 Fleming Street, number 204. The court is also calling the suffix 7465. That's Windsor Property LLC versus occupants at Hamburg. I have received a proposed order of dismissal in this matter from the plaintiff's counsel, Mr. James Abbott. I will grant that petition now. I'm signing the order accordingly, dismissing the matter without prejudice. The court calls the suffix 7128. That's Strongco versus Richard Ingram and other occupants of property at 21734 Moros. That matter, Mr. Abbott is the plaintiff's counsel in that matter and has indicated that the matter is being dismissed. And the court is awaiting that dismissal, so this matter be closed out upon the presentation of the dismissal. The court calls the suffix 6774. That's Ordale versus Anthony Bale regarding property at 727 West Grand Boulevard, number 218. The court calls the suffix 3029. That is Mishima LLC versus Christelle Ashford and other occupants of property located at 11768 Whitehill in the city of Detroit. The court is calling the suffix 4868. This is N and N Assets LLC versus Latasha Hudson and Willie Jones and other occupants of property located at 12526 Lang Street. The court is calling the suffix 7461. That's Do Ha Properties LLC versus occupants of property at 19271 Binder Street. The court calls the suffix 8427, strike that 8472, Sylvia Green versus Shantivia Walker and other occupants of property at 20430 Hubble Street. The court calls the suffix 8480, that's DRO Fund LL, strike that DRO Fund 1 LLC versus Harisha Whaley and other occupants of property at 18509 Burwood. The court calls the suffix 8484, that is DRO Fund 1 LLC versus Kathy Jackson and other occupants of property located in the city of Detroit at 20277 Blackstone.
I'm here.
Your appearance for the record at this time, counsel. I believe that Mr. Mr. Abbott is counsel in each of these matters, and Mr. Abbott's P number is 26085. I believe he's in another Zoom. If there are attorneys on the other side of any of these matters, please identify yourself at this time and address the matter that you.
Yes, hello. I'm Richard. I'm Richard Ingram.
I'm talking to attorneys now. Attorneys.
I'm sorry. I'm sorry, Your Honor.
Your Honor, Charlene Snow from United Community Housing Coalition, P26923, on behalf of Ms. Ashford in 3092.
Just one moment. I do have 3092 in front of me, and I do see that Ms. Ashford, Christelle Ashford is on this Zoom. Is that correct, ma'am?
Yes, she is here.
All right, and good morning to you, Ms. Ashford.
She's muted. Ms. Ashford, you got to hit that microphone button to turn on the mic.
Well, good morning to you nonetheless. Your attorney is speaking now. You may proceed.
Your Honor, it's our position that the case should be dismissed. Ms. Ashford moved out of the property in December 2019, well before this case was filed. I believe the case was filed in 2020, January 2020. The lady had been out of the property for a year. Ms. Ash, and I've sent, unfortunately just this morning, but I've sent Mr. Abbott by email a copy of Ms. Ashford's lease at her new location. And that lease was entered into on December 4, 2019, and runs from December 4, 19 forward at a different address. There is also attached to it a notification to the Detroit Water and Sewage Department dated 12/16/19, and it's someone wrote received on the top of it, that she had moved out, and letting the water and sewage people know the dates during which she lived at the address on White Hill and when she moved, so they could make adjustments to her account with the water bill. So it's our request that the matter be dismissed.
All right, and I take it that you have not heard back from Mr. Abbott regarding this matter?
No, I have not. And in all fairness, I did just send it to him this morning. I don't know what we can do with that if Abbott's not on the line. Unfortunately, this is not a Boydell case, so we can't deal with Ms. Burke either.
I will, what I'm going to do is if, at this point, what I would do is I strike Ms. Ashford from this matter. I noticed that the plaintiff had occupants of the property as well. I will strike Ms. Ashford's name from this matter and dismiss her from this case. I will allow the execution of a writ regarding the property as to occupants. And since Ms. Ashford is not there, that would not apply to her. But moreover, I'm granting an order dismissing her from this case. All right.
Your Honor. Can I clarify with Ms. Ashford on the record that she has nothing remaining in that property?
At this time, Council.
Ms.
No,
Ashford,
ma'am. No, ma'am, I don't.
you've got everything of yours out of there?
Yes, ma'am. I've been gone a year. Yes.
Okay, just want to make sure because they may send the bailiff out and I don't want your stuff there.
I have nothing there. I'm sorry. I'm really loud. I'm at work and I'm in a factory, so if I'm yelling, I'm sorry.
I understand. Look like you're working. All right. We got you. We got you, Miss Ashford. All right. So you're dismissed out of this case, ma'am, and we wish you well.
Thank you, sir. Thank you, Miss.
You're welcome. You can go ahead and leave the Zoom, Miss Ashford. I'm going to need to talk to you about the other items regarding your present address, though, because we'll have to start a new file. Okay. I'll call you later.
Yes, ma'am. Thank you.
Okay. Thank you, Ms. Snow. Other attorneys on any of the other matters that I have in front of me at this time? Just one moment. If you're on this Zoom and you're an attorney on any of these matters, please speak up now. Just one moment.
Judge, to intermeddle, this is Lockhart. On that last case, I don't think you put a writ execution date or inquired as to whether any occupants of the property are connected on this Zoom.
All right. Thank you. Thank you, Mr. Lockhart. I regret to say that you're correct. Are there any other persons who might be occupying this property on White Hill, 11768 White Hill? Say something if you're on the Zoom. All right, and I will assign the writ in this matter, allow for execution on or after the 29th of January. All right. In regard to the case 8452, that's involving Tony Coates and other occupants of property on Fleming Street, number 204. If you are on this Zoom, please say something this time. Tony Coates or any person occupying 2468 Fleming Street. And I see Mr. Abbott is there. Your appearance regarding the matters that I've called your matter, sir.
Good morning, Judge Coleman. My name is James Abbott, P26085, representing Malaysia, the plaintiff.
All right. In the last case, I just did one of your cases that involved the suffix. You just took that one. That was the suffix 092. Ms. Ashford was dismissed out of that matter, wherein she said that she had not lived in the property for a year and had no belongings there. The court did allow for a writ to issue in that matter for execution on or after the 29th of January against any and all occupants on the premises.
Thank you.
And I've called all other matters that had with your name on it, sir. With regard to 452, it does appear that no one has appeared on that matter. This also appears to be a first hearing. So the court is going to reset that matter for the 5th of February, 25/21.
Latasha Hudson.
Please keep yourself quiet on the Zoom until we call your case. Thank you. At 9:45 a.m. Regarding the suffix 774, this is involves Bordell versus Anthony Bale. The last time this case was called, there was some indication that the defendant might have been in hospital. Defense counsel, do I have Mr.
Please leave your message for.
Do I have Mr. Bale?
Yes, you do. Hello, Anthony Bell is online.
All right, thank you, Mr. Bell. I see you there, sir. And you live at the property on West Grand Boulevard, number 218. Is that right, sir?
That is correct.
All All right, thank you, Mr. Bell. Mr. Bell, you have a chance to speak with a lawyer regarding your matter that you have in front of me and regarding your rights and how you might get this matter resolved, sir. Have you had that opportunity?
Well, I have not. And the last notice that I have has no information on it other than a hearing. And I have relocated. So I'm in Florida now and have left that property as of November 25th.
All right. So this is a complaint. Mr. Abbott, the gentleman says that he's no longer at the property. Your pleasure at this time, sir.
Mary Burke, are you on the line here?
I am.
Did Anthony Bell turn in the keys?
No, we did not.
Turn in some papers
Did you know he was out?
that they sent.
No, I did not.
Want to adjourn us and check?
I saw them.
Check and
I
maybe.
can we adjourn it for 5 minutes? I'll call over there.
Well, and they do not have the keys. They are actually in the mail along with the remote and a note. But I did have DTE disconnect or remove the services from my name back to Boydell mid-December.
Are all your belongings out, sir?
My belongings have been out since November. Yes.
Okay.
All right, very well. So, counsel, and it sounds like a matter that would in fact be dismissed. And you want a day or two to investigate this, Mr. Abbott?
Yes.
That would be prudent.
All right. All right. So I'm gonna put a control date to set this over for Tuesday next week. That is the 19th of January, 9:00 a.m. That's just to verify that the plaintiff has access to the premises. And Mr. Bell, given that this is not a complaint that has a money judgment claim, if you're out of the property, then the case would simply be dismissed. It does not mean that the plaintiff may not seek to bring some other action for money, but at least the landlord-tenant part would be dismissed. That is my anticipation in this case. You understand, sir?
I do, but you were broke up. Will I receive another notice? Because I did provide my Florida address back in early December. So will I receive something?
You have your notice. You have your notice now. I gave you January the 19th at 9:00 a.m. Just check back in at the same Zoom number that you have. Got it?
Okay. And then also to be able to see the complaint, how do I access that?
I don't know. And why are you interested in the complaint when the case is going to be dismissed?
Well, I'm just trying to understand what the complaint is, because again, I have, a hearing date. I have no information as to why.
I'm not trying to make that more complicated for you. What I'm saying to you is that you moved out of the property. The complaint was saying that you got to pay rent or move. You moved. So part of that has been resolved. And only I tell you, just write to the court or come down and pick up a copy or whatever. But I can't really tell you this pandemic stuff. So just zoom back in on the 19th, and it looks like if they can verify the move out, that would mean that this case would be dismissed. Dan?
Thank you.
All right. Wish you well, sir. Be safe.
Mr. Abbott, can you hear me?
Yes, I
Couldn't
can.
Mr. Abbott send him a copy?
NN assets been called?
I am dealing with cases now. What is it talking?
Everybody.
Yeah, it sounds like the court reporter is making a record again. Ladies and gentlemen, I have a process that we're going through here. I have 4 cases in front of me that I called. I'm working through each one of them. If you've not heard your name, that means I haven't called your case yet. So right now we're dealing with the suffix 8468. That's Latasha Hudson and Willie Jones regarding the property on Lang Street. Everyone else should be muted on this call so that we don't get too much noise in the system. Do I have either of those persons on the Zoom on Lang Street? Say something if you're here.
Yes, I'm here, Latasha Hudson.
All right, I'm looking. All right, I see you up there, Ms. Hudson. Good morning to you. You live at the property on Lang Street, is that correct, ma'am?
Yes.
All right, just one moment. All right, Ms. Hudson, and this is your first time coming to court on this matter, is that correct, ma'am?
Yes.
All right. Now, we understand that you do have the right to the assistance of an attorney, and that in talking with an attorney, you may be able to find out what your rights are and also programs that may be available to help you and assist you with resolving this matter. You understand, ma'am?
Yes.
All right. So I'm going to give you someone that you can talk to help you and assist you in regard to trying to resolve this matter. Since it's the first hearing, I am going to set it over for a new hearing date that's going to be on the 8th of February, 2/8/2021, and that's going to be at 9:00 a.m. That's the next date that you're going to come back into a Zoom using the same information that you already have. February 8th, 2021 at 9:00 a.m. Right now, I'm going to set it up that you can talk to a lawyer that can help you and assist you in trying to get this matter resolved. You understand, ma'am?
Yes.
So in just a moment, you're going to receive a notification on your device. It's going to tell you to go to a particular breakout room. Once you have that, then just click on and you'll be in the breakout room with the lawyer that you can talk to. Who's available to talk to Ms. Hudson at this time?
Lockhart can do it.
All right, thank you, Mr. Lockhart.
Mr. Lockhart, excuse me, Judge, does he want to take one of the, either the law, I think we have a law student. We may also have a social worker.
I was going to be asking that Ms. Sharap, if she's not due to leave to go back to class, come in to break out with us.
All right, we'll send Ms. Sharap there. That's all right. And so Ms. Hudson, you're receiving a notification now. You see it, ma'am?
Yes.
All right, just go there. Mr. Lockhart's going to meet you there, and Ms. Sharap is going to meet you there as well.
Judge, before I'm gone, I'm going to need to address file 960 scheduled at 10:30. If you could put a post-it in case I'm not available when you call it.
Yes, sir, I do. That's 960.
Correct, sir.
All right, very well. And I do have that one, and I will make sure that I see you before we call that. Thank you, sir.
Thank you, sir.
All right, I'm looking now at 7461. That is the occupant of property on Binder Street, 19271 Binder Street. If you reside at that location, please say something in the Zoom at this time. It is a termination action before the court. I will go ahead and reset the matter. I'm going to set this over for the 29th of January 29th, 2021. That's going to be at 9:30 a.m. If the defendant does not appear, the court would be inclined at that time to grant judgment by default. The court now references the suffix 8472. That is Shantavia Walker, or occupants of property on Humble Street. Say something if you're in the Zoom at this time.
Hi, I'm here.
All right, and what's your name, ma'am?
Shantavia Walker.
All right, thank you, Ms. Walker. And I'm putting your name in there, just one moment. And of course, you live at the property there on Hubble Street. Is that correct, ma'am?
Yes.
All right. All right. So, Ms. Walker, I know that this is your first time coming to court on this case. You have not had an opportunity to talk with a lawyer regarding this matter to discuss how you might be able to resolve this matter and discuss your rights in this case. You have not had an opportunity to do that, have you?
No, I haven't.
All right, so I'm going to set it up so that you can speak with someone and they can go over your rights and discuss ways that you might resolve this case. I'm going to go ahead now and set your case over for the next action date that I have in this matter. That's going to be the 8th of February at 9:00 a.m. February 8th, 2021, 9:00 a.m. You'll use the same Zoom number that you have now and Zoom back in on that date, and we'll discuss your case further. Right now, I'm going to set you up with someone that can talk to you and help you to go through resolving this case. Discuss your rights. Who's available to talk at this time?
I think it's me, Your Honor. There's only Lockhart and myself in the courtroom today. My understanding is that Ms. Willingham is ill this morning.
All right, so Ms. Walker, I'm going to send you to breakout room number 2 with Ms. Snow, Attorney Snow, and you'll receive a notification on your device, ma'am. Right about now, Ms. Walker. Let me know when you receive it. You have it, Ms. Walker?
Got it.
All right, and Ms. Snow, I'm sending you there as well.
Your Honor, could Joe Linden, I believe, is a student, a social work student, could he come in the room as well?
All right, what's his device under?
Linden, L-I-N-D-E-N. I think that's his name. Mr. Linden, is that you?
Yes, that's me.
Yeah.
Oh, gotcha, sir.
Wednesday.
He's a Wayne State student.
Yes, and welcome.
Thank you.
Daughter of Wayne State. Go ahead.
Joining now.
There you go.
So we're going to breakout room 2.
Got her back up.
The next matter that I have is 8480, and ladies and gentlemen, you will have to keep your devices muted until I call for your matter. That is involving Carisha Way, regarding property on Burwood. If you're on the Zoom, say something at this time.
Okay, all right, okay.
Whaley on Burwood Street. If you're on the Zoom, say something at this time. All right, this is the first hearing regarding this matter. Defendant did not appear. I will set the matter over for the 29th of January, 9:30 a.m., 1:29, 21, and 9:30 a.m. New notice will be sent out. Defendant does not appear before we be inclined to grant default judgment at that time. I'm looking now for the 8484, that's Kathy Jackson, person occupying property on Blackstone. If you're on the Zoom, please say something.
I'm here, Your Honor.
Thank you, Ms. Jackson. I do see you there. And you do live on the property on Blackstone, is that correct, ma'am?
Yes, sir.
All right. So this is your first hearing on this matter. Have you had an opportunity to talk with a lawyer regarding your rights and opportunities to resolve this matter, ma'am?
Actually, I talked to the legal aid people that came with the paper.
Okay.
And I talked to them. They haven't nobody called me back yet.
Okay, fine. So what we're going to do is we're going to set it up so that you can, whoever that is, you got to silence your device. But we're going to set it up so that you can come back on the 8th February 2021. That's going to be at 9:00 a.m. That's the new day that you'll Zoom back in. Today, I'm going to set it up so that you can talk with a lawyer that can assist you regarding your rights and other information that pertains to this. Ms. Jackson.
Yeah, it's hard to hear, Your Honor. I'm sorry.
All right. So you got the date to come back into the Zoom. Is that correct? Did you get that?
Yes, sir.
All right. So what I'm going to do, I'm going to get a lawyer for you to talk to today that can go over what your rights are and discuss possible ways that you can resolve the case, all of those kinds of issues regarding this file. And then you'll come back to see me on the 8th of February. You understand?
Thank you, sir. Yes, I do.
So I don't have a lawyer in the Zoom right now, so just stand by, ma'am. Mute yourself.
I sure will.
Come back to you as soon as I get one of the lawyers that can talk to you, right?
Okay, sir.
No, I'm saying, remember I gave you the homework assignment to go look up those two things that kill the lymphoma cells.
All right, this is case number
23. Okay, but didn't I text it to you? Didn't I text you?
Okay, this is 23-4-8492. This is Alden Towers versus Keith Russell, R-A-S-U-L Jr. and other occupants of property at 8102 East Jefferson B501. The court calls the suffix 8496. That is City Property Management Group versus Jessica Griffin. Another occupants of property is 16115 Burt. One moment.
Trying to figure out exactly.
Your appearance at this time, please, Counsel.
Good morning, Your Honor. Mark Corey, P. 82210 on behalf of plaintiff for these matters.
Thank you.
For the Alden address, I'm pretty sure it's a dismissal. Could you just repeat that address for me, please?
Yeah, that's 8120, sorry, 8102 East Jefferson B501.
Okay. I'm looking at my records. Yes, Your Honor, that should have been a dismissal, and it looks like we would have sent it in a while ago, but if we haven't received that, we'll be sending in another copy.
All right. I will note on the file that the matter is dismissed, and I'm awaiting an order on this. I've had a switch up in clerks and that, so that may have been what happened there, right? So in regard now to the suffix 8496, that relates to Jessica Griffin at Burke Street. If you're on the Zoom or any person at that address, please say something at this time. If you live on Burke, please say something. I'm looking for Jessica Griffin. If you're there, say something. All right. It is a first hearing regarding this matter, and under the administrative order, I am going to set it over for a next action date where the defendant has not appeared. I'll go ahead and set it for the 29th of January. And we'll set that on for 9:45, January 29th, 9:45 a.m. The court is inclined to grant a judgment by default if the defendant does not appear at that time. Thank you so much.
All right. Thank you, Your Honor. Have a nice day.
All right. Likewise to you, sir. Today. This is case number 234850. This is GAL LLC versus Sharon Mitchell and Demetria Griffin. Property located at 3803 Elmhurst. The matter is before the court on the filing of a complaint for non-payment of rent. Counsel, your appearance for the plaintiff at this time, sir.
Good morning, Your Honor. Andre Maximkov, P number 77071, appearing on behalf of plaintiff.
All right, thank you, counsel. Good morning to you. Do I have Sharon Mitchell or Demetria Griffin, anyone living at the Elmhurst address? Please say something if you're on the show. All right, it does look like this is the first hearing regarding this matter. It does appear that the defendants have not appeared regarding this matter. I will set it over for the 29th of January at 9:30 a.m. With a renotice for that date.
Thank you, Your Honor.
All right, thank you, sir.
Have a good day.
All right, likewise to you, sir. This is case number 234850. This is Logical Property Management LLC versus Natalie Brianna Jackson and other occupants of property at 12120 Stoughton, apartment number 2 in the city of Detroit. I saw Mr. Landau there. Mr. Landau, are you there? Do I have Ms. Jackson present or any person living at the Stoughton address? If you live at the Stoughton address, apartment 2, Natalie Brianna Jackson, and any other occupant of that property, say something at this time. It appears the defendant did not appear regarding this matter. The court, given that this is the first date, the court will set a new date regarding this matter and provide new notice. That date is going to be the 29th of January, 2021. The court will set the time at 9:30 a.m. on the 29th of January, 2021. I know that Mr. Landau is not in the Zoom at this time. He was here earlier. He'll be notified of that date of January 29th, 2021 at 9:30 a.m.
Judge, I just came in.
Following 504, defendant did not appear. This is the first hearing on this matter. The court set it over for the 29th of January, 2021 at 9:30 a.m.
I'm sorry. What was the date?
January 29th, 9:30 a.m.
Thank you.
All right, thank you, sir.
I think that's the only case that I have before you this morning, Your Honor.
I think so, sir, to my great disappointment, but we'll take what we can get at this time. Have a good day, sir.
Might as well. You too.
This is case number 20. Mr. Fleshland, are you there somewhere? There you are. All right, this is
Yes,
case
Your Honor.
23-4-8508. This is Kingman Holdings LLC versus Carlicia Wright and other occupants of property located in the city of Detroit at 15360 St. Mary's. The matter is before the court on the filing of a complaint for non-payment of rent. Counsel, your appearance at this time, sir.
Yes, Your Honor. My name is Dennis Flesland, P30289, appearing on behalf of the plaintiff. I am standing in for Mr. Sagatti this morning, Your Honor.
All right, thank you, counsel. And do I have Carlisa Wright on this Zoom or anyone at the St. Mary's address? Carlisa Wright or anyone living on the St. Mary's address, 15360 St. Mary's. Say something.
Yes, I'm here.
All right, what's your name, ma'am?
Carlicia Wright.
All right, thank you, Ms. Wright. And Ms. Wright, I'm just putting your name in here so I know where you are. And have you had an opportunity to talk with a lawyer regarding this matter and regarding rights that you have and ways that you may resolve the case, ma'am? Ms. Wright? Ms. Wright, you've not spoken with a lawyer, have you?
Can you hear me?
Yeah, I hear you. Can you hear me?
Yes, I can hear you. No, I haven't spoke with anyone.
All right. I want to give you the opportunity to talk with a lawyer to discuss how you might be able to resolve this matter and to just go over what your rights are. This is the first hearing on this case, and so the court is obliged to set a new next hearing date. I'm setting that date for the 8th of February, 2021. You would return into the Zoom with the same number that you have on that date of the 8th of February, 2021, and that will be at 9:00 a.m. Right now, I'm going to set it up so that you can talk with a lawyer and go over what your rights are regarding this matter. So just hold tight, ma'am. I have one person in front of you, and after that person has had a chance to talk with someone, I'll get you out. I'll get you into a breakout room to talk with someone as well. You understand, ma'am?
Yes, sir.
All right. So just hold tight. You got your new date. Is that correct, ma'am?
Yes, February 8th, 9 a.m.
All right. Perfect. Perfect. All right. So I'll come back to you shortly. Regarding Miss Kathy Jackson, she's still there. That's Mr. Abbott's case, filing in 484. I told her I'd give her a chance to speak with a lawyer. She's coming back on the 8th of February, 2021 at 9:00 a.m. as well. Ms. Snow, are you available to talk with her at this time?
Sure, I can, with Miss Jackson.
Yes, ma'am. Yes, ma'am.
Okay, and I think we may want Mr. Linden. Has our law student left us, Mr. Lockhart?
I don't see him here.
We had a law student, maybe her time, they only give us a couple hours.
The law student is still in breakout.
No,
It appears Mr. Linden is available.
Yes, that's what I was gonna say. Mr. Linden's here. He can go back in with me, with Miss Jackson.
So I believe that the two of you have the prompter for breakout room number 2. And so you can go back to that room, and I'm sending Miss Jackson to that room now, to number 2. Ms. Jackson, you'll receive the notification in just a moment. There you go. Have you received it?
Yes,
Just go ahead and click it, ma'am. You can be in the breakout.
thank you.
All right, thank you, ma'am. Good day to you.
His finger throbbing like
Mr. Lockhart, I'm on the record regarding 23466, strike at 6960. This is Willa Williams versus Rashid Saeed and Danielle Saeed and the occupants of property located at 4861 Kensington Street. Your appearance for the record, counsel.
Judge, Police Court, Steve Lockhart, P32090. My understanding, Ms. Willingham has been involved in this case, but she got called away this morning. I am prepared to assist defendant in this case. Need to address when Your Honor, please.
All right, just one moment. And ma'am, your name for the record, the owner of the property there in Kensington, if you will, your name, ma'am.
Willa Williams.
All right, thank you, Ms. Williams. And let me go to Mr. Lockhart and find out what issue he's raising at this time, and I'll come back to you, Ms. Williams. Mr. Lockhart, you may proceed, sir.
Judge, it's my information that Ms. Willingham has had some conversations with pro per plaintiff, Ms. Williams, attempting to resolve this case. It appears they're unsuccessful. I do not know if defendant is here. It appears defendant is not connected. However, from my conversations, it would appear that there are some defenses to this termination case. One, based on the adequacy of the notice to quit. Two, especially vis-a-vis whether there is a written lease and rental agreement in this case. I'm saying that cold and I'm saying that blind, but I would be requesting an adjournment to look at those issues. If this case can't be resolved, we need to bring those issues up on behalf of the defendant. But at this point, I know Ms. Willingham has talked to the defendant, but I have not myself.
All right, so let me ask that question. Is Saeed, Rashawn, or Danielle, either Saeed on this Zoom? If you're anywhere here, say something at this time.
Yes, I'm here, Your Honor.
All right, and what is your name, ma'am?
Danielle Saeb.
All right. How are you pronouncing that last name? Say it again.
The H is silent, so it's Saeb.
Saeb. All right. All right. Thank you, ma'am. Just one moment. Put your name in here.
Judge, I apologize, but it looks like Mr. Linden did not get sent to that breakout room with Ms. Snow.
Is that right? Let's take care of that. Just one moment, Ms. Williams. One thing.
You spent it?
What?
That 40.
Oh, maybe he did.
Yeah, I don't see him.
Yeah, he sent a chat that he wasn't connected, but now I don't see him. I apologize for the interruption.
Let me see what's going on. Oh, yeah, he's here. Yeah.
Okay. I'm sorry.
No problem. He's got it worked out. Okay. Counsel, go ahead, sir.
Judge, I could go to breakout to interview Ms. Saheb, but I think what would be more appropriate is just to adjourn this matter so we can look at what we've got. I would need a copy of the complaint and the notice, and I'm not sure that our office has access to the court files the way we did in the past. And I don't know what documents Ms. Saheb has.
All right, I did adjourn this matter from a previous date recently, and that's what one of my concerns is. Ms. Williams obviously wishes to go forward to try and get this matter resolved in some fashion. And I believe that this matter was in front of me a few weeks ago. And I set it over for today's date. Ms. Williams, when were you here? When was the last time that you were here, ma'am?
Last Wednesday.
Last Wednesday?
Yes, sir.
I don't know, for some reason, it seemed like it's a longer time than that.
This is the third appearance.
Yeah, in this pandemic, that's not unusual, but I thought that this was ready for trial the last time that you were here.
Yes.
So I set it in short order to try and get back for trial. Remind me, was the defendant represented by counsel the last time that you were here, Ms. Williams? I don't remember.
At the last visit, Ms. Syed said that she had not spoken to an attorney. You put her in a breakout room. When we came back, we ended up with the new adjournment day.
All right, got it. Okay, I recall now. And that was Ms. Willingham that spoke with her on the previous occasion. All right, Mr. Lockhart, I kind of want to move this forward as quickly as I can because we are dealing with a proper plaintiff. But if there are issues that you have to raise, then it is indeed appropriate that you defend to the best of your ability with regard to this matter. I'm going to put you and Ms. Sahib in the breakout room, and I want you to come back and tell me what realistically how we might be able to go about going forward with this matter as best as you can tell. If it feels like pressure, no pressure, but if it feels like pressure, then it is what it is.
Yeah, I'm used to it.
So you're in breakout room number 1, Mr. Lockhart. You can go back there. Ms. Syed, I'm going to send you to speak with Mr. Lockhart, and I'm going to be waiting for the return. It may have to be adjourned, ma'am. I'm going to try to keep it as close as I can so that I can get to the issues in this and have a hearing of whatever we need to do to get it resolved.
May I speak, Your Honor?
Yes, ma'am.
I did talk to Ms. Syed's attorney. She called me. She said she was going to get with her client and call me back. She never did that. She wanted 3 weeks to adjourn the case. I told her of the importance of us being able to get it resolved now.
Yeah, let me stop you there. That's enough. You're going into some discussions that I should not know about without everybody being involved.
Okay.
And Mr. Lockhart, the attorney that's standing in, he may want to speak with you after you talk with Ms. Saeed. Ms. Saeed, did you receive the notification to go to the breakout room, ma'am?
Yes, I did. Thank you.
All right, go ahead and go to the breakout room, and you'll come back in together with Mr. Abbott. And Mr. Abbott may want to speak with you, Ms. Williams. Let's see if we can get somewhere with this today. If not, we'll try to figure out what we do next.
Okay, thank you.
Thank you, sir.
Your Honor, did we finish the Carlicia Wright matter? I think she was going to meet with an attorney, but nobody was ever assigned or accepted her case.
I'm waiting on a lawyer to be available for her.
Okay.
And I have already set the adjourned date that she's coming back, and that's
right. I wanted to figure out who the lawyer was. If you're going to wait, I'll just wait also then.
It's either going to be Mr. Lockhart or Miss Snow, and
okay.
both of them are preoccupied at this time.
I gotcha. That's fine.
All right. Thank you, sir.
Your Honor.
I haven't called a case, but what is it, sir? Who's talking to me? Talk.
Oh, I'm sorry, Your Honor. I didn't know that you called my name or not. I think I missed it.
All right. What's your case number, sir? What's the last 3 digits on your case number? Last 3 numbers. 3 digits.
128.
128. All right.
Yes, sir.
We're looking. Just one moment.
Thank you, sir. Thank you, Your Honor.
Judge, this is Lockhart. File 128 was Abbott, and you dismissed it per Mr. Abbott's request.
Exactly right. The plaintiff attorney in that matter. Thank you. Yeah, the plaintiff attorney in that matter indicated that this case should be dismissed. And so I'm just waiting on the order of dismissal in this case. That's your understanding too, correct? Mr. Ingram, your understanding was that it should be dismissed as well, correct? Mr. Ingram, you hear me?
Yes,
Did you-
yes. Oh, yes, sir. Yes, yes, Your Honor.
All right, yeah, it's gonna be dismissed.
Okay, Your Honor, I hear you. Yeah, yes, I hear you now. I'm sorry.
All right, now, not a problem, sir. All right. Good day
Okay,
to you.
thank you, sir.
Judge,
Okay, so I'm all set then. I can leave?
1 second, Mr. Lockhart.
Judge, I went to breakout room 1 for Miss Saheb, and did you send her?
That's on another case. Okay. All right, yeah, you can leave.
I'm sorry.
Mr. Ingram, you can
Okay,
leave
thank
now.
you, sir. Thank you, Your Honor. You have a
Yeah,
blessed
this-
day and you stay safe.
All right, thank you, sir. Thank you
Thank
for
you,
your
sir.
patience.
Thank you, sir.
Mr. Lockhart, she had not gone there immediately because Miss Williams was talking. And once I stopped Miss Williams, and she went on to the breakout room. So I think you may have been coming out when she was coming in.
Oh, I do
She
see
was
her
in
on
breakout
the,
with me.
Oh, put her in the wrong room.
Mistakenly in number 2 with me and myself and Ms. Jackson, the lady in the red shirt.
Yeah, I messed up, Mr. Lockhart. Second time this year.
I'm playing the lottery. I'm playing this Dayton lottery.
I just sent her to number 1, and
Yes,
she's
sir.
there. So, thank you for correcting that. Thank you, Mr. Snow.
Your Honor, I want to know if you called my case also. I've been waiting.
What's your name, ma'am?
My name is Elizabetha Porter. I've seen you before. This is my second time.
All right. The last name is what?
Porter, Porter.
All right. What's the last 3 digits in your case number, ma'am?
460.
Yes, I did call that case. Mr. Lockhart was on that, I believe. 460. Just one moment.
Yep, it's adjourned.
Let me see. Yeah, that case, he was not on that case. That case is adjourned until the 5th of February, 2021. And have you spoken to a lawyer? I think, did I connect you to someone the last time you were here?
No, sir. I had won the case. They never did. You told me not to pay them my rent until March until they fixed. I had 40 pictures. The landlord only approved 8. They have been sending me false eviction notices. And they just sent me another one from this court date saying that they sent me
Okay, when I tell you to stop, man, you have to stop. This case that is in front of me was filed in October of 2020. That's a new case within the context of the time that we're in. And the first hearing date was in December. And so as a result of that, the case had to be set for today's date as the first available day. This is the first hearing on this case. You may have had other cases. This is the first hearing on this case. And therefore, I've set it over for the 5th of February, 2021. You do have the right to the assistance of a lawyer and someone that can go through this case with you and discuss what your rights are and also what opportunities may exist to resolve this matter. I cannot let you talk about the details of the case because the other side is not here and could not get in those details, but I can appoint you someone that you can talk to so that you'll be prepared to go forward with regard to your case on the 5th of February, because that's the next date you come back to see me, February 5th at 9:45. All right, so you can unmute yourself, ma'am. I had to mute you because you were talking and I said, stop talking. I can't let you go on. Stop. So if you know how to unmute yourself at this time, Ms. Porter. Ms. Porter. So keep working at it, ma'am. You need to unmute yourself so that you can talk to me now. I want to set it up so that you can talk to a lawyer in a
I was
breakout
about to
room.
say, I don't even know. I'm like, I don't even know how to unmute.
All right, you
This is
got
my
it.
first time using Zoom. I'm sorry.
Yeah, that's okay. That's okay. We're patient here. You've been a bit. So I'm gonna. Did you hear the things that I communicated to you, ma'am?
Yes, you said I come back at February the 5th at 9:45.
That's correct. But right now, I'm going to give you an opportunity to talk with a lawyer so that you can go over the issues that may be a part of this case and be ready to fit the February. You understand?
Okay, thank you very much, Mr.
So in a moment, just stay where you are. In a moment, you're going to get a notification from me to go to a breakout room. Now, I'll let you know when I'm sitting and sitting, and then you'll click on to.
Okay, thank you.
Okay, so just hold tight, Ms. Porter, for just a moment.
Okay.
Somebody was waiting to talk with a lawyer. Is that Ms. Saeed?
Yes.
Oh, okay, wait a minute.
Miss Wright also, Your Honor.
Ms. Wright is what?
We have to wait.
All right, Ms. Wright, you there?
Yeah.
Thank you, Ms. Wright. And Mr. Sagati, Mr. Blessing is making sure that I prioritize this matter. I'm going to get you to someone. Ms. Snow, are you able to talk with Ms. Wright at this time?
Yes, I can, but Your Honor, if I could respectfully ask, is that Elizabeth Porter that's on here? Because I think it's a different case ending if it's Elizabeth Porter.
My name is Elizabeth Porter, but my name is Elizabetha Porter. They always spell my name wrong. Like,
Right,
spell it
and
wrong.
is your case 20342-460? I may be
ma'am.
wrong, Your Honor, but I have a note that a writ was withdrawn on that one.
Exactly, with Mr. Fantera.
Yeah.
He's not the attorney
Yes.
anymore. That's what I was trying to say. He's not.
Ma'am,
That's okay.
hold
Ma'am?
tight and let the judge
Yeah,
talk
listen.
to you.
Yeah,
Sorry.
yeah, what happened on that case is that the attorney did in fact appear. He pointed out to the court that you had paid the money on that case already, and somebody submitted a writ and they shouldn't have. So the writ was withdrawn and that case is closed. That case is closed. So you don't have another pending case and you don't have to come back on anything. What happened is that I was talking to you about a case I thought was yours because it ends in 460. Your case ends in 4602, but the earlier numbers are different from this case.
Yes.
So I had the wrong case. Your case is closed. They erroneously filed for a writ to evict you, and they couldn't do that. So that writ was withdrawn, and the case is closed. All right, Ms. Wright, you understand, ma'am?
Can I still talk to a lawyer though, Your Honor?
I can't let you talk to a lawyer when that case is dismissed. If they file another case against you, what will happen is that you'll come back before me or one of the landlord tenant judges, and when you do, they will set you up with a lawyer to talk to. Right now, there's no case pending against you. You understand?
Okay, so don't come back on the 5th?
No, don't come back on the 5th. Your case is closed. They may file another case. If they file another case regarding some rent that they believe is owed, when you come to court, then just ask for a lawyer, and they will appoint you a lawyer so that you can talk to somebody and then work through it with your lawyer. You understand?
Okay, thank you, Your Honor. Do I leave now?
Yeah, you're all set now, man. All the best to you.
Okay, thank you, Your Honor, and Happy New Year's.
All right, thank you. Happy New Year to you as well, ma'am. All right, Mr. Lockhart, I see you. Let me put Miss Wright with. Thank you so much, Ms. Snow. That I was looking at the file, does not have Ms. Porter's name in there, but she mentioned them, those last 3 digits, and so I was going with the digits. So thank you for catching that. That could have been disastrous. All right, so Ms. Wright, I'm going to send you Ms. Wright to speak with Ms. Snow, and that's going to be in breakout room number 1. Ms. Snow, you're in number 2. All right, number 2. So Ms. Wright, you'll receive the prompter in just a moment.
Okay.
Yeah, Ms. Snow, our client does indicate that they are interested in EDP, just so you know.
Well, we gotta wait because EDP is done.
Oh, no,
So we
I
wait for
understand,
the
but there, whatever
Just
assistance program, yeah, our client is interested in pursuing that. So
Okay.
just so you know.
Yep, Your Honor, can the law student, Miss Sharab, come with us, please? And I know Lockhart's trying to raise his hand. I think he's trying to get into another room.
All right, Mr. Lockhart.
When I went to the breakout room, the last person that Miss Snow interviewed is still there.
Jackson?
Jackson. She cannot figure out how to leave the breakout room. I told her to disconnect and try to reconnect to the court, but I think she's still sitting in the breakout room.
No, she's not.
He has not been sent to a breakout room to join me. I think we got our rooms crossed.
Okay, we can get all that straightened out. So Mr. Lockhart, where do you need to be? You need to be somewhere.
I would like to be in a breakout with Miss Danielle Sahib.
Okay. So I'm,
Saheb, maybe I mispronounced that.
all right, so I will
Saheb,
change.
if you're connected still, please.
I'm moving her out of that breakout room 2. I'm moving her to number 1. But
I
it
see
looks
it.
like, all right, you got it, ma'am? So just
Yes,
go
I
to
do.
the, click on, and you should meet Mr. Lockhart there.
Okay, thank you.
All right, and so Ms. Wright is in breakout room number 2, and Ms. Snow is going there.
And
Ms.
the
O'Leary-
law student from U of M, Nina Sharap.
Oh, I thought Mr. Linden was there. Well, I'll put Mr.
Doesn't
Rock there.
matter, either one of them.
Put me in there as well, Your Honor. Thank you.
Okay, I do go on back, Lynn, and Mr. Rock, I'm going to put her there. I'm going to move her out of. Two. That's a lot of noise going on there.
Your Honor, you can hear me?
I hear you loud and clear.
I'm sorry. My name is Rashawn Green. I've been sitting in here for a minute. I don't know if I missed the appointment between me and Curtis Murphy. I actually came down to 36th District. I had no Zoom information, but I found that out when I got down there. So I had to come back home on the bus and I logged in when I got home.
What's the last 4 digits on your case number? Last 3 digits.
472.
Last 3 digits or 4 digits?
Yeah, last 3.
003.
003.
All right, what happened on that case? I think a default was a default error.
I don't think it was in.
Madam Court Reporter, you can chime in. This is a good time for you.
Oh, okay. It was dismissed.
Yeah.
It was dismissed?
Yes.
All right, your case was dismissed, sir.
Okay, thank you, Your Honor.
All right, it's not pending against you. All right.
Okay.
Good day to you. All right,
You too. Happy New Year and stay safe.
Otherwise, stay safe, sir. Miss Nina, are you still there? I thought I sent you somewhere. Are you still there, ma'am?
I'm sorry,
Yeah,
me? Yes,
Yeah.
I'm still here.
You didn't get the prompter from me?
I did not. Okay, I can see it now.
Okay, all right, go right ahead. All right, this is case number 20-34-8512. This is River Towers versus Danny Nguyen and other occupants of property located at 7800 East Jefferson, apartment number 1, circuit apartment number 1226. Do I have Mr. Rabbits? Anybody standing in for Mr. Rabbits? Do I have Mr. Danny Nguyen? Do I have Mr. Nguyen? Anybody on this matter? All right, this is a complaint for non-payment of rent. I don't know why no one has appeared regarding this matter. It is the first hearing. So we're going to set it over for the 8th of February. And we'll set a new date, the time at 9:15, and we'll do re-notices on this. All right, I see a Richard McLean in this matter, sir. Mr. McLean?
What's going on?
Mr. Lavasher, you have something else in front of me, sir?
Yes, Your Honor. It's ends with 195.
All right, my clerk stepped away, so tell me what Tell me which case that is, sir, if you will.
This is a land contract forfeiture. We have not been able to effect service, and we're coming here today to request permission to serve via posting in first-class mail.
All right, and if you will, sir, I don't have the file in front of me, so call that case number in the file for me, sir, if you will.
Your Honor, the case number is, the case name is James Properties versus Annette Jones. It involves property located at 10111 Somerset. The case number is 20-349195 SP.
Thank you, Counsel. Your appearance regarding that matter, sir.
For the record, Randy Levasseur, P41712, appearing on behalf of the plaintiff.
And Counsel, I understand that with regard to that matter, you've not been able to effectuate service in a matter that is a complaint for land contract forfeiture. Is that correct, sir?
That is correct, Your Honor. The process server made 3 attempts at the property, and each instance received no answer at the property. We do have an affidavit from him. We also do have a proposed order for alternate service, which I can send to the court. We're asking that the mayor be adjourned and that service be allowed by first-class mail, as well as tacking or firmly affixing to the door at the subject property.
All right. Do you believe that service by alternate means is reasonably calculated to effectuate actual service in this matter, sir?
Yes, I do, Your Honor.
All right. The court will grant the petition for alternate service in this matter and will allow service by means as indicated. The court will sign an order upon presentment and will set the matter out for, I think, February the 8th would give you enough time to effectuate service in this matter. Is that correct, sir?
I believe so, Your Honor.
All right, so we'll set it for February the 8th at 9:30 a.m., February 8th at 9:30 a.m.
Thank you, Your Honor. And how should I get this to the court?
You're sending it to, in my mind, Carmen. I'm not sure. What's the last name?
Thanks.
I don't know why Banks didn't want to come out. Must not have enough money. Carmen.Banks at 36districtcourt.org.
Carmen, and that's with an EN, if I recall hearing it earlier, .banks at 36districtcourt.org. I'll have that to you momentarily.
Thank you, Counsel.
Thank you, Your Honor.
And Ms. Williams, I know you're there, and we're holding tight for right now.
Yes, sir.
Yeah, I say somebody took because it was froze slush. I
Oh,
ran out.
oh,
I'm like,
goodness. Can't put that down.
you can't. They took it out the refrigerator. I had took it out the freezer and set it on the counter in the kitchen. You know what I just talked about?
See? Mr. Coleman, the back, sir?
Yes, Your Honor.
Yes, you had something else, sir?
I had a case for Mr. Ravitz. That was 11 o'clock.
Yeah. Oh, you standing in for him?
I am.
Oh, okay. What I thought no one was here because the defendant did not appear.
No,
on that matter.
I told Madam Clerk earlier this morning I was going to be here and I'm going to be back in a little while. I apologize.
All right. We just didn't get that note. So I just called it a few moments ago. And what I did is I went ahead and set it for the 8th because it was a first hearing and I was thinking that maybe Mr. Radish did get here, but that defendant, this would have been his first opportunity. So I set it up for the 8th of February at 9:15.
So February 8th at 9:15?
Yes, sir.
Yep.
Your Honor, always a pleasure. You and your staff have a wonderful day. See you
Likewise,
tomorrow.
sir. Always good to see you.
Okay. You too, Judge. Take care, Randy.
I think he's muted.
Take care, Fred.
Okay. Your Honor, I went blank for a sec. You did say February the 8th, right?
Yes. And what time did I say?
9:15.
9:15.
Thank you, Judge.
But you got one more case?
Yeah, I've got people in the breakout room. I have Ms. Williams on the Zoom. So we're waiting.
Your Honor, I have provided that proposed order to Ms. Banks via email.
All right. She's going for it now and get it signed.
Judge, I'm gonna take a quick break.
All right, I'm at a report. Very interesting. You've done it?
I'm gonna try it this week. I got it from Dr. Sabi.
Dr.
Sabi.
Okay. Sounds interesting. I'm signing that order now, sir.
Thank you, Your Honor.
Your Honor, are we waiting for more people to talk to someone? I see a couple names and
I'm Miss Willa Williams is on the Zoom. She's on the other side. She's the plaintiff in that case. And Mr. Lockhart is speaking with the site. So we're trying to work through that process a little bit. I don't have anything else here. I had a case earlier with Ms. Proc and Ms. Willingham was on the other side of that, but neither one of them.
Oh, yeah. Has Ms. Parock come into the courtroom yet?
No, and it was set for, I think it was set
Early, yeah.
So I called it earlier and Ms. Proc was not here. That's not like her. So I was mindful to set another date and send out another notice.
I can try to reach Ms. Willingham. It may be that they've got an agreement or something. I don't know.
That would be helpful.
Let me try that. I know that she was, Mr. Lockhart said she had some health issue this morning. Let me see if I can reach her.
You want a flower and horse.
Yeah, today.
Yeah, you can do that. Yeah, I have to stay away.
They got shrimp too. You want some?
I'm sorry.
I said they got shrimp too. You want some? You sure? Or you just gonna wait till Friday?
It's Friday.
Fish Friday?
Oh, yeah. Yeah, who doesn't? Who probably does Fish Friday?
No one that I know of.
That's what-
Just a traditional thing.
You have your own stuff. Where do people go out to lunch around?
I don't know. They be getting in their current right now because ain't nothing open downtown.
Yeah.
Like I said, well, crispy chicken, basin burger.
Mason Burger, what is it?
It's a burger place, and they got can't believe it's not meat, and they got bean burgers too if you don't want the red meat. Cottage Inn's open. Some Chinese place where Cottage Inn is open is open. Jose's Mexican food is open. Yeah, like I said, it's a good number. Oh, Applebee's is open. And yeah, and I have.
And of course, everything is on the carry out.
Mm-hmm. Yeah.
Basically, 3 times almost shut down.
Mm-hmm. Yeah. I think Harbor House is back open. But yep, they don't want you sitting. I go crispy chicken, put some fish.
The one down.
Nine, 6-0. I also have this 60 for that. I think setting in the paper. All right, welcome back, Mr. Lockhart. And Ms. Williams, of course, is still waiting here. I wanted to know if you needed to speak with her or whether we could make some progress on this case today. Obviously, Ms. Williams is anxious to see the case move forward. The defendant has raised issues, and of course, those issues have to be addressed in the court setting. If you think,
Are we on the record, Judge?
no, we're kind of off the record on this. Go ahead, Mr. Lockhart.
Judge, can I recite where I think, just my understanding of the case at this point?
All right, sir.
Okay. I know Miss Williams is connected. Miss Saheb, are you now connected and listening to this?
Yes, I am.
Okay, very good. Judge, it's my understanding that these parties, that this is a two-family flat, that in either June or July, the plaintiff started this case with a termination notice to quit. I do not have a copy of that notice, but my client would say that sometime in possibly June or July, a notice to quit was received that she doesn't have any longer or doesn't have available. Now, apparently, some issues occurred between the parties prior to that Miss Williams, the landlord, approached the Sahebs, their upstairs tenant, and said she wanted to start showing the place for sale. During that time, the Sahebs said fine, but they also showed Miss Williams that they didn't have power at all in a couple rooms of the house and another repair problem. And subsequent to that, nothing was done on the repair. But then Miss Williams showed up at their house unannounced with two people to show the house to. And Mr. Saheb said, well, no, you got to call us first. We can't let anybody in right now. You give us the courtesy of a call. And either Mr. Saheb or Miss Williams, at the end of all this, the police were called. And then there's a notice to quit. So we got a potential issue of a retaliatory eviction, given that the Saheb didn't let Miss Williams come in when she shows up unannounced. And they get the notice after they said, hey, by the way, we're not getting what we pay for in rent. Now, there's apparently a rental agreement, a lease. Miss Saheb does not have a copy of that, and I haven't been able to look at it. And I don't know if the termination notice gave any grounds for termination, but Miss Saheb seems to think that lease expired in May of 20 prior to the notice to quit. And again, if we have a holdover month to month, I don't know how the lease reads. Some leases automatically renew for another year. I don't have the lease to look at, but there's a potential that Miss Williams would have to state on her notice to quit the grounds under the lease by which she's terminating the tenancy. Now, my client would also acknowledge that she has not tendered rent, and the landlord has refused rent ever since summer of 20. My clients have been looking for new housing, but haven't found it. They have a line on a place that may be available, but not till March. And I've told them that's not realistic about a vacate date, trying to work a resolution. But in my conversations with Miss Willingham, Miss Williams, I would characterize as, and because she's pro per, she doesn't know the law and she's not going to trust an attorney for the tenant. Miss Williams allegedly wants a court order to have these people out today, despite Miss Willingham in good faith saying, well, that's not how the law works. So, Judge, that's kind of where we sit today as best I can decipher.
So I do see that when this, what I can tell you what I have in the file, I have a document that is offered as a notice to quit. It indicates that it was served first class mail on the 16th of May, giving a move out date of June 19th. Attached to that is a cover letter and also the lease agreement in this matter. At the end of the lease document, just it's evidentiary issue for simply the citizen.
Judge, I apologize for interrupting, but I'm missing what you're saying. There's a lot of background noise. Maybe Miss Banks is the culprit.
I was thinking that was the court reporter.
No, it's the court clerk. I hear it too.
I was thinking that was the court reporter, but maybe it wasn't. Thanks, as she was the one around here that's actually working.
Thank you.
And in any event, the lease document says the lease was entered into on the 16th. It was signed by the landlord on the 16th by the tenant.
Of what month and year, please?
Let me get there, Mr. Maka.
I'm sorry.
May of 2019. And I looked at the document to see whether or not there was an automatic renewal provision, and I'm not seeing that, although that would not be my my job to find that. Obviously, that would be something that council would want to look into to see if something like that might exist. Or if there's some language from which.
Your Honor, may I speak?
Not until I'm finished. You
Yes,
messing up
sir.
like
I was just gonna tell you where it was on the lease.
you were doing good. And,
I've been trying, sir.
the long and short of this is that it sounds like the plaintiff has raised some issues that the court would indeed have to conduct a trial or a hearing on. If the plaintiff prevailed at the trial or hearing, then the court would issue an order for a defendant to move within 10 days of that date. And if the defendant did not move, then the plaintiff would have to file an application for a writ, after which the court issue a writ. And in the writs that I'm issuing now, because there's a preference in this jurisdiction right now for a delay in issuing writs and having people evicted out of properties because of the pandemic. That's the realities that we're dealing with. So all of my writs are being signed with not being able to be executed until after the expiration of a certain amount of time. So within that rubric, it makes sense that if the tenant is making some efforts to move out of the property, notwithstanding how long the case may have been going on, that it might make sense for the parties to see if there is some reasonable middle ground that you can reach, because if the longer that the case, for lack of a better way of putting it, the longer that the case is delayed, and there are automatically delays because of assertion of rights. When the longer that it's delayed, of course, the longer the tail is before you get to that part where that can actually be an eviction from the property. So that's just the truth of the way that these things go. So I don't know. There was some talk about not being able to move out until March. That's not a realistic. That's not a realistic time frame. But what would make sense here is for a sure move out date short of that time, given the fact that if Mr. Lockhart says he has to review documents before he can proceed in this matter, then that will require an adjournment in this case. Then I conduct the hearing, and then I issue the judgment. That's going to allow some time. Then after that comes the application for writ. That's going to allow some time. So you some of that is pandemic related. Some of it is just the Summary Proceedings Act. It's the way that the law works in these cases. So I can't force anybody's hand, but it would seem to me that some reasonable degree of compromise and give certainty to both sides is probably the most reasonable way to deal with this, rather than the court making a step-by-step decision that's going to affect time and additional time. If the parties can somehow reach something that works. Now, if this was a case where the tenant was basically saying not moving, that's a whole different issue. The tenant here is saying that she's moving out of the property. The landlord says she wants it now. The tenant says she needs a bit more time. Maybe somewhere in the middle you can find a way to resolve this. And I tip my hand, so to speak, in this, because even if I conduct a hearing and find everything in the plaintiff's favor, if I do that, that does not solve the issue of time. It doesn't solve that issue. It may result in this person won, that person lost, or whichever way it is. It doesn't resolve the issue of the lapse of time. So this case is not going to be a case where someone's going to have to move out in January. Best case scenario in sometime in February. Worst case scenario is that it ends up sometime in March. That's what this case looks like.
Yes, sir.
Judge.
Let me hear from Ms. Williams. I'm coming back to you, Mr. Lockhart.
Thank you, Your Honor. the reason that this was issued altogether was not for non-payment of rent. It was for failure of the SIABs for allowing us entry into the unit. They know that we were selling the property. We told them that in February, and that's the reason why. They were always given notice when we were attempting to bring someone over. We have lost 2 potential buyers. If we could get access to the property, that would help us to be able to do something. That's a compromise. Just let us into our own property. We can't come in because of the dog. This is very dangerous.
Let me stop you with that part. In as much as the matter is under the court's jurisdiction, the first thing that happens here is that I can order your right to come into the premises. We can make it a 24-hour notice or a 48-hour notice. If you desire to come into the property, all you have to do is give notice, and you can make entry into the property, and the property has to be made available to you. And obviously, if there's a violation of that order, the court could then issue an order for a writ, can issue a default and order for writ where there's a failure to do that. So that part of it is, unfortunately, we can't go backwards, but going forward, that part of this case is easy to resolve. The defendant is not claiming any ownership interest in the property. Therefore, the plaintiff has the right to make entry into the property upon giving notice of the same. And that notice can be as short as 24 hour notice. A lot of times people look at 48-hour notice, but it can be as short as 24-hour notice, where there is a clear notification that I'm coming to the property to inspect, to have someone to do a walkthrough, to have buyers to take a look at it, whatever. That will be a court order that allows that to happen. So that part of it is the easier part of this to resolve.
That was the main reason why we wanted them to move, because that's the only way we could get in. As I spoke to Ms. Willingham, I believe the attorney, I told her that now I'm working, my mom lives with me, so I have to take care of her, so we can no longer take care of the property. And that's the reason why we haven't been pushing on the SIABs the whole summer. We have never refused rent. Some of the information that Mr. Lockhart said was inaccurate. We have never refused rent. They were paying electronically. So there was no refusal of rent. They just stopped paying after April. They no longer paid and then refused. But every time we attempted to get into the property, notice was given by email, by text mostly. So we always were trying to do that. And the violation is against item number 8, on the lease. And the lease also states in the very last paragraph that once the 1 year is up, it goes to automatic month to month. I sent a letter to the SIABs in April notifying them that they were about to satisfy the 1 year responsibility, just putting them on notice that they're about to satisfy it. And at the end of that, on the 16th of May, that's when we issued the notice to quit, which was like, you did your year, now we need our house because we need to sell it. We need to move on to trying to take care of my mom. And I would have to get my realtor in order to go in, because I can't just come and do a inspection right now. I would have to make arrangements with somebody.
Well, so let me deal with that first, ma'am. I will sign a court order that allows you to make entry.
Answer on. Answer on. Answer.
That will allow you to make entry on the property upon 48 hours notice.
Would it have to be myself or a representative?
It could be yourself or a representative. Okay. You could notify Mr. Lockhart, have someone notify Mr. Lockhart.
Okay.
Well, either way, I guess what I'm saying is that would be a matter of a court order. it would be that, that if the tenant doesn't do that, the tenant would be in default, which means that that would be the end of this case. It would be a default. I sign a judgment and a writ that will allow for eviction. So, you know, it's just, it would be as strong as any provision in your lease, only stronger because you have a court order saying that has to happen.
Yes, sir.
And Mr. Lockhart knows the strength of that, and he will explain it to his client. It's unfortunate that we didn't get to this at maybe some earlier time, because if you want to get into the property, I'd give a court order for you to get into the property. And you can go there yourself, you can have a realtor to go there, or whoever you want to go to the property. If you give notice and say that you're coming, and that notice is 48 hours before they show up, and that person, they have to let them in. Otherwise, you notify the court, and I'll sign a judgment saying they've got to move out of the property. So obviously, you have the right to inspect, even if you want to sell it. But if you desire to sell and move forward with your property, certainly this should not be held up by not being able to get into the property. So,
Well, I would like to do that. I would like to be able to get the notice to be able to grant access to us to get into the property, so that we can proceed that way.
Judge, as indicated, we have a fact dispute. My client said she has absolutely no problem with that, with reasonable advance notice. The issue is there's a fact dispute that supposedly plaintiff just showed up unannounced at a very bad time. But again, fact disputes aside, we would agree to that.
I mean, that's you anticipated my next statement, Mr. Lockhart. That factual dispute, unless we deal with some other issues in the case, that factual dispute cannot be resolved in a way that is favorable to anybody at this point that has any meaningful impact upon this case, except as it relates to some other issues. But going forward, it doesn't matter whether somebody showed up without notice or showed up thinking they're given notice or whatever. Going forward, I will sign an order that says that if the defendant is notified telephonically, by mail, by email, that as long as that notice is 48 hours prior to the landowner coming to the property, the landowner herself or an agent may come to the property and enter the property and make inspection of the property upon the giving of 48 hours notice. So that would deal with that part. I'm sorry, sir.
I just sent a chat to my client with a proposed resolution. Ms. Saheb, I know you saw the chat function earlier. Will you look at that and let me know? Judge, I'm trying to see if we can resolve this right here and now.
Yeah, I mean, this part of it is a major bridge. So you may be able to address some issues. So what are you seeking to do, Mr. Locker? You want to talk with Ms. Williams or you talking with Ms.
Judge, I have proposed that we agree to a vacate date of a month from today. Ms. Saheb realizes that's not, she doesn't currently have secured the new housing by that date, but she sounds so close that I think if we agree to surrender possession by a month from today, she's going to be able to comply with that. Ms. Saheb, do I understand you'd be willing to obligate yourself to a court order to vacate within a month? Whoops, did I lose you, Ms. Saheb?
She's still here.
Oh, can you hear me?
You're on mute, ma'am.
She's off.
Hello?
Yeah. Say we hear you
Yeah.
now.
Yes, I responded to your chat too, and yes, and that's fine. I do agree to move out by that day.
And during that period, ma'am, if you get reasonable advance notice, knowing in advance that Miss Williams wishes to bring some people by to take a peek at the place, you will not interfere with that, that you'll make every reasonable effort to have the property available on the dates and time indicated. If you get reasonable advance notice, and in this case, we'll make it 48 hours.
Yes. Yes.
All right, you understand that the notice thing and being able to get inspection of the property is going to be an important part of this. If Ms. Williams is able to agree to the extension of time, you would have to make sure that you respond to the inspection. Otherwise, what would happen is the amount of time that you have would be short. You would, the writ could actually be executed before the date that I'm going to set if you didn't allow the inspection. You understand?
Yes, I understand. Just make sure that I comply with the 48 hours. Otherwise, that could affect the mid-February move out date. Is that what you're saying?
Exactly right. Exactly right. So, it seems to be a simple thing, but I wanted to make that real clear because what would happen is that the writ could actually be executed anytime after January the 25th. But if you, as long as you're in compliance, then it could not be executed until after the 14th, effectively after the 15th of February.
Oh, I see. Okay.
So that
Judge, by the way.
Go ahead, Mr. Locker.
Being picky, the 15th of February appears to be a court closed day for President's Day, but just so for however we're fashioning that.
Yeah, so what's happening is that the earliest that a bailiff could be out there to execute would be on the 16th because of the weekend, and then you have the 14th, Sunday, and then the 15th is a court closure day. So it'd be the 16th. Even if I set it at the 13th or the 14th, it's the 16th. So we'd be looking under these circumstances that I would allow for a writ to be executed on that day, or after that day, if the tenant is not moved. That means that, if you want to be out of there, you want to be out of there on the 16th. That's it. Okay. You're not out there on the 16th. If Ms. Williams contacts the bailiff, there will already be an order from me that says that if she contacts the bailiff, that they're to make this a priority. Nobody wants that to happen, but my order would make it a priority if you're not gone by the 16th of February. You understand?
Okay, I understand that. Yes.
Yes, sir. Collectively, I guess I have to agree. It's been so long. We just want to.
I think it's a reasonable way. Oh, I'm sorry. Somebody was talking. Go ahead. You broke up a little bit, Ms. Williams.
I'm sorry. I do want to make sure that we still have the ability to have access now to go in. That's what is truly important. I try to express that often when you are selling properties, the purchaser wants tenants. So, my goal is to get this done. So I am fine with the February 14th move out date, as Mr. Lockhart has said, but I also would like to have access prior to with the 48-hour notice so that we can see the condition of the property. I already know that there's a broken window on the driveway side, in the dining room. We saw it from outside. And I don't know what condition we're going to find when we get in there because, they're just not being able to get in.
You cross that bridge when you get to it, but those two factors under this order, those two factors would be resolved. It's under this court's jurisdiction that you give the 48 hours notice. It could be by email, it could be telephonically, it could be dropping off a letter, whichever way, reasonable means of communication that you're coming in, set the date and the time that you're coming to the property, and it has to be made available. Now, a lot of times what happens is that is a court order. That's the way that this is done. People knowing that they're under court order for this to happen, sometimes what people do is send a notice and say, this is when we're coming. The person will call and say, okay, can it be at this time? And then you work it out. But if you can't work it out, my order will control that. Sometimes people can talk and say, we'll be there at noon. And they say, wait a minute, I won't be home until 2 o'clock. Then you can say, okay, it'll be 2 o'clock. And we got it worked out. In other words, you don't have to do it exactly the way that I say do it. Right. But if all else fails, do it exactly the way that I say do it. You know, if all else fails, follow my protocol and for that, and on that basis, you have a reason to say that, Judge, you should allow the writ to execute right away because they won't let me into the property. I don't think that that's going to happen. I think that you've reached a reasonable way of resolving it. That this should resolve the issue between the parties, and it gives certainty on both sides as to what happens from this point.
Okay, do we send notice to Mr. Lockhart or where do we send the 48-hour notice?
And you guys can work that out. Mr. Lockhart, Mr. Lockhart's going to prepare an order, if you will, sir.
Yes, sir.
And then you'll get a copy of that order now. We'll email it to you. Ms. Saeed is going to get a copy of the order as well. Everybody will know how this case goes forward. And we can decide right now how you want to go about the notice, whichever way.
I'd like the notice to be emailed to me.
Okay, I'm talking about the notice, when you give the notice regarding when you want to go to the property.
To see
Would you like to email that to Ms. Saeed? Which way do we want to do it? Do you have an email address for Ms. Saeed?
I had one. I'm not sure if it hasn't changed, and I still have the Miss Saeed. But if she could give it to Mr. Lockhart and I can get it from him or something, just to make sure we have recent information.
We're going to put it in the order.
Okay.
The email address where you are to send the notice, with that email address put in the order that you're going to receive. Mr. Lockhart will need to get your email address so that we can send you a copy of the order. Once I sign it, he'll make sure that you get an email copy of it. And Ms. Saeed will get a copy as well. And that order will it'll have the language about the 48 hours. It will have the email address for you to send the notice, and everybody will be clear on what they need to do.
Judge, may I?
Yes, sir.
I will give my phone. I don't have the phone or emails for any of these parties. I am prepared to give my phone and email right now. I don't want them to have to do it over Zoom, but if I could do that, could I ask, ladies, both of you, immediately reply to me with your phone numbers so I can coordinate this?
Right, go right ahead and give them your number, Mr. Lockhart. You will need to
You both have a pen and pencil?
Yes, I can send it to you in the chat if you like.
Oh, sure, that would be excellent. Miss Saeb, can you also chat me your phone and email? Miss Saeb, you're on mute.
Sorry, I was
okay.
Sorry, I was already in chat trying to send it. I can do that, yes.
Very good. Please, neither of you disconnect from the court hearing because then you can't chat me. But if you will both chat me your phone and email, I am going to reduce Judge Coleman's wisdom to writing and send it to you both.
Thank you so much.
Mine has been sent, email and telephone number. To you privately, Mr. Lockhart.
Ms. Williams, I have that, but you need to hold on. Don't disconnect till I can write it down out of chat.
Okay, I won't.
Thank you, ma'am.
I'll shut the system down until you get it.
Thank you, Judge. I'm old. You guys got to be patient.
Old, I don't know. My definition of old has changed substantially since I turned 60 last year.
A lot older than you, Lockhart.
Oh, man.
I've taken it hook, line, and sinker where they say that 60 is the new 40.
Well, please, one moment, please. Miss Saheb, oh, hold on. Judge, thanks for your indulgence. I have both Ms. Williams and Ms. Saheb. Unless you had further questions for the judge, if he releases you, you can disconnect.
I have one question for the judge.
Williams, go right ahead, ma'am.
Your Honor, I'm hopeful that this works out, but if it doesn't, when am I able to contact my bailiff to be prepared to execute on the 16th? How early?
As I don't know, but I'll tell you this much: my writ is going. My signing of your writ is going to be quick and for immediate execution if the occupant is not gone on the 16th. So what you'll want to do is contact the court by phone, and that's 965-8712. Reference the case number.
Okay.
And advise as to whether or not the tenant is in the property or has moved out, or if the tenant is still there. I will sign the order and it'll be sent over to you the same day. And all you have to do is contact the bailiff, because the instruction on the order will be that the tenant that is to be executed.
Okay, great. Thank you.
Okay. So the intent of the court's order is for everybody to have certainty as to what occurs. That's the nature of this. Okay. So with this agreement, it's to set up a situation where they're not delays, where the parties are able to get to the conclusion that each side wants to get to, and that they do that with the court's the force of the court's order. That's what this is about.
Thank you very much.
All right. I wish you all well, Ms. Saeed, Ms. Williams, Mr. Lockhart. You'll get a email copy of the order from him. He's going to get something to me. I'll sign it right away, and you'll get a copy.
Thank you, Your Honor.
Thank you.
Thank you.
Your Honor, if I might, on that case you were asking about that Miss Willingham and Miss Parikh were involved in.
Yes. 684.
I've spoken to Ms. Willingham. She emailed me something that I've forwarded to you and to Ms. Banks. It's my understanding from Ms. Willingham that they don't know why the case was on your docket today, because they believe they sent in an order that was entered a while ago. And also the ladies moved out. But I think they had an order. We were going to pay a small amount of money. Lady was moving by a particular date. And Miss Willingham thinks that was entered in maybe October or November.
I'm looking at it now. Yes. Yeah. Yeah, that was an order controlling what would happen in the case. We must have set a control date or something.
Could be.
That this got up some came back sometime. But yeah, that order appears to be dispositive. I'm going to go ahead and close this file.
Thank you.
I happen to have been the drafter of that document.
There you go.
That's why it looks so archaic.
I wasn't going to say anything. Is that a typewriter or what?
Oh, it's a hunt and peck, Judge, and I don't know how to change my font.
Yeah, I was looking for some whiteout, but I don't see any places with whiteouts. All right. Well, you got it done, and it was done well enough for me to put my signature on this. All right. So I think that we are all set. I want to thank the law students that were here today, helping out on this docket. I hope it's been every bit the learning experience that you wanted it to be. I really appreciate you, the two of you being here, Mr. Lynn and Ms. Nina, because I have a hard time working on the last name. Thank you so much for being here.
Judge, may I interject?
Yes, you may, sir.
I notice on my screen, I have 2 cell phone numbers
Yes, sir.
that are on mute. Okay.
Mr. Heeb is yet here as well. And Mr. Heeb, you know that you can zoom out now if you like to do so. So on the 2 numbers, if you're on this Zoom and you need to speak with me, say something now. I see this.
You're on mute.
Yeah, you're on mute. I see 1734 phone number ending in 6770. I see a 1248 ending in 6065. If you're on the Zoom and you'd like to speak up, go off mute and say something to me. Okay. I got done all the cases that I can do today. So I don't know who those persons are.
Judge, would either of these been people you muted yourself on your end because they were interfering?
If that's the case, I wouldn't know for sure at this point, but I don't think so.
Just a thought.
I don't believe so. Yeah, that is a worthy consideration. So I'm not sure. I think if we're all set.
This came.
And looks like I have that's the order that's in the file, Ms. Snow, that was previously signed. All right, yes. All right, thank you.
Thank you.
I've indicated that file should be closed.
Thank you. The 2 people on the phone don't come forward. I guess we are done.
Yeah, I guess we are. They're not saying anything.
TIF.
Yeah, they're not saying anything, and I don't have any other files in front of me. So we're gonna call it a day on this.
At 36,
you
that's
well.
36 TH
Do I
District
see
Court.
either of you tomorrow?
Yes, I will be there tomorrow.
Thank you.
It's filled out.
With 1 file, I think.
With 1 file, all right.
You're welcome.
Actually, I have a couple with you also, Judge, but I'm gonna have Miss Snow handle them for me.
All right, we won't try to.
Okay.
Extra. All right. I always seem to have some more I could send there, but boy, stretching the resources right now is something. It's amazing that we